So as I was saying, this webinar is organized by the EDPS and EDPB trainees, and is mainly aimed at the trainees of other European institutions, bodies, and agencies. So welcome to all participants. We really hope that you will find this session insightful and educational. So now on the substance of the event, against the range of measures which have been deployed around the globe in order to tackle the pandemic, with today's webinar, our trainees aim to unveil how our rights to privacy and data protection are being affected by the current crisis, subsequently examine the repercussions that the measure which has been so far taken have been, and explore, thirdly, the long-term impact on our fundamental rights. I'd like, of course, to grant a special thanks to our speakers who join us today. We're very grateful for your presence. In order of appearance and speaking, Wojciech Wiewiorowski, Christopher Kuhner, Maria Paz Canales, Gary Davis, and Isabel Verrecken. We are really delighted to have you here. So without further ado, I would like to welcome the European Data Protection Supervisor, Wojciech Wiewiorowski, and kindly ask for his introductory speech. Wojciech.
Thank you very much, Anna. Wojciech Wiewiorowski. I'm the European Data Protection Supervisor, which stands for this abbreviation that Anna was using, EDPS. And EDPB, European Data Protection Board, is the group of the data protection authorities from all the countries of the European Union, the European Economic Area, so also from Norway, Iceland, and Liechtenstein, who are getting together in order to help us to harmonize approach to what is the new data protection regime, new data protection law in Europe. New, but not that new, meaning the principles of data protection, the principles of privacy are with us from at least 1995, when the first directive on the data protection has been established, but actually from much later times. In 70s, the first data protection law started to appear in Europe. You are probably not aware of the fact that this year we have the 50th anniversary of the first regulation of this kind, which have been taken in the German land of Hessen. And later on, the national legislation have been created in the Western European countries, as well as in the countries of the other regions. At the moment, 140 plus countries in the world have the comprehensive data protection regulation. All of them, and all those that don't have this kind of regulation, have met this year the crisis that was the crisis of its kind. It has never been the situation like that before in the world, that the pandemic has actually switched off the normal life in most of the continents, in most of the countries, and established a completely extraordinary situation. And this is the topic that our trainees have chosen for the discussion today. Our trainees, because this is the conference which is not organized by neither of these 5 persons that you can see right now on the screens, neither of these young ladies and these old men who are here. That is done by the youngest people and the newest people in our community of the EDPS, which are the trainees, helping us and helping the Secretariat of the European Data Protection Board for the last 5 months. The extraordinary group of trainees, because that's the first group of trainees which I never met in the real life. We are all online throughout the whole their stay in the institution. And at the same time, they could continue the tradition that started already some years ago to organize the conference for the other trainees, but also for the other people who are interested, where we are able to present what are the current topics connected with the data protection and privacy protection. They had an opportunity to have the topic which really touched everybody in the world. there are pros and cons of the situation. They also had no other choice, actually, because that was the main subject that they were discussing during their stay in the European Data Protection Supervisor's office. And here you have the possibility to meet the people who were directly involved in the works on the data protection issues during this crisis, including the representatives of the civic society, including the representatives of the lawyer society and academia, but also the people who were involved as the data protection officers, and at the same time the developers of the solutions which were helping us in this process. So I'm really very happy to see here Maria Paz Canales, Gary Davis, Christopher Kuhner, and Isabel Verreken, who will be presenting you how it looked like. First of all, remember that we will just touch a fraction of the questions which appeared at the beginning of this crisis. The fraction of the questions which were really thrilling for the data protection community at the beginning. I can tell you that just in the middle of March, we wanted to present the strategy of the European Data Protection Supervisor for another 4 years. But we decided to postpone it because we actually found out that there was nothing in the strategy about the most important subject which started to be on the top of the newspapers in March. And moreover, we didn't know at this time what will be the influence of this crisis was the whole idea of fundamental rights, data protection and privacy protection especially, but also to the whole idea of European Union. Well, we have to remember that one of the first reactions to the crisis was to close the borders. And for me, for the person who is coming from Eastern Europe and who remembers what, before 1989, what it meant to have closed borders, that was actually the moment when somebody has stolen my Europe. My Europe, which we were able to join in 2004 as Poland, my Europe, which I started to work for, have been actually taken from one day to another because of the COVID. But now, after this 3 months, I may say that the data protection regulation, data protection attitude among the people have shown that this is something more than one of the laws that we have. This is something more than one of the fundamental rights. This is the idea, this is the value through which we filtered all these tools which have been delivered to us either by the national authorities or by the European ones, or by the global developers of the solutions, I may say. And that's something which I can say about the unusual couple of Apple and Google working together and presenting their own interoperable solutions in order to help to fight the crisis. Let me finish with the words that when I first met Gary Davis and a representative of Google sitting at the same conference, same meeting, let's say, presenting the same project, that was something which I made a print screen of in order to have in my archives the situation where these two companies were presenting the common project. But after that, I had numerous opportunities, the last one yesterday, to hear them again, saying about the cooperation that they have established in order to help, in order to present something new, something interoperable, something which may be one of the outcomes, the possibility of cooperation of the big giants. I hope that it will also be true that this crisis has shown the member states of the EU, but also the Global Privacy Assembly, that only working together we can face the challenges which are global and will look exactly the same, no matter if you are in the center of the jungle or you are in the center of the big city. So let's see what happened last months and what was what were the challenges for the privacy protection and data protection this time. Anna, back to you.
Thank you so much, Wojciech. Thank you for sharing your reflection with us. I'd like to take this opportunity to kind of remind those who join to please unmute yourselves when you are present in this seminar to have a better connection. Thanks again, Wojciech. It's now my pleasure to introduce our next speaker, Professor Kuhner. Christopher Kuhner is Professor of Law and co-director of the Brussels Privacy Hub at the VUB in Brussels. Professor Kuhner is also a senior privacy counsel at the law firm Wilson Sonsini in Brussels. We are delighted to have you today. The floor is yours.
Thank you very much, Anna. I'd like to, first of all, thank Wojciech and the organizers of this event for having me here. It's a real pleasure to speak to you. I think I have a maximum of 15 minutes, but I will quite likely maybe be even less than that to leave more time for discussion. I have no slides, so you'll just have to watch me this whole time. First thing I'd like to do is to congratulate all of the Blue Book trainees for attending this webinar in such numbers. It's quite impressive. As young officials or young lawyers, you need to find an interesting field to work in that also has a good future, and I can say data protection is it. We're used to thinking of data protection and privacy only in relation to phenomena such as use of online social networks and things having to do with the economy, but we can see from the discussion here today that it also has implications for important issues of the public good. And that's one thing I hope you can take away from this event today, that the data protection is a key area for society, the economy, and the future of the world. So it's also something where you can really work for the public good. For example, at the Privacy Hub, we just did a handbook together with the International Committee for the Red Cross on data protection and humanitarian action. So there are many other areas besides what you may read or think have thought about in the past where data protection is implicated. And thus, I hope you also consider data protection for your future careers. And I would say those of you who are trainees at the EDPS and EDPB, you've made a good choice. I think I can say that with confidence. So our time is limited, and I'm going to therefore focus only on a limited number of points because that's all I have time for, and really only, I think, 3 points. My first point is that COVID raises a number of important questions about how we as a society balance important public values, including data protection and privacy protection. We've seen, as you look at the news, that in many countries around the world and many regions, including the EU, intensive data collection and data processing have been proposed or are already being used to fight COVID. And you can see examples of this very easily. For example, apps to trace contacts or contact tracing through other means, temperature checks at the airport, immunity passports, etc. I think I don't need to enumerate those further. And this involves then the processing of data that can identify an individual, which is called personal data under the GDPR, and therefore it implicates data protection. The GDPR and the EU legal framework don't necessarily prohibit these activities, but they do subject them to certain conditions in order to protect our fundamental rights. And in particular, 3 important conditions are that there has to be a legal basis for this sort of data processing. It has to be laid out somehow in the law or provided for in the law. There must be limitations so that the data processing is limited to the purposes for which the data were originally collected. And there have to be limits on passing data on to other parties. And other conditions also exist, such as good data security. And I think you can see these are all things that are quite logical and reasonable, but they are provided for in the law. And in Europe, we're lucky to have this legal framework to protect them. It's also important to say none of these.
I'm sorry to interrupt. And I'm taking the liberty to interrupt just because you said that we will have watched you, just to let you know and to notify that actually I'm told that no one can see you in case you would like to switch your camera on, only because
Really?
you said that upfront, and I'm taking this liberty to tell you, no, we can't benefit from watching you.
Yes, thank you for telling me that. Can you see me now?
Now it works. Thank you so much.
Okay, I'm sorry about that. I don't know what happened,
Okay.
but at least you could hear me. I hope so.
Yes, yes.
I'll continue. I'm not going to repeat everything I've been saying. So it's important to say none of these conditions, or maybe it would be better with my camera off. You can decide that maybe later on in the presentation. None of these conditions or data protection law does not prevent data collection for fighting COVID. As I said, and I think the GDPR does have sufficient flexibility in it to allow for data processing in public health emergencies. Sometimes there has been perhaps some discussions in the press that seem to be seeing data protection as being in conflict with public health, and that's not the case at all. But there is a kind of inherent tension between data protection and the need to process data for important reasons of public interest. So there are these conditions that need to be satisfied, and that's I think what we're really talking about here. No one is disputing that data protection needs to serve other important public interests, but data processing needs to be done in accordance with the legal framework that we have in the EU. So my second point is that there are real risks to data protection and privacy in this sort of data collection, and it opens the door in some cases to surveillance by both public and private actors. Certainly, the effective fight against COVID can lead to quite extensive data collection, and many different actors in both the public and private sectors would like to have access to this data. So you can think of, for example, you could ask who could like to have this? Well, law enforcement authorities, insurance companies, drug companies, et cetera. This doesn't mean that they're all doing it, but you can see that there could be an interest there. And in particular, I think there's also a risk that even if data processing is allowed to fight COVID initially, there's a risk that data collection could continue even after the risks of COVID have been diminished or addressed. And this is what I would call mission creep. And I think there's a real risk of this. This is, to my mind, when someone asked me recently, what is the biggest data protection risk in collecting data to fight COVID? And this was my answer, is of course, there can be excessive data collection to begin with, but I think it's more that allowing the data collection initially might lead to it becoming institutionalized and might lead to it being used for other purposes beyond which it was originally intended. And we can see this in certain countries. For example, outside the EU, there are certain countries that have had seeming success at fighting COVID using data collection, but where there is criticism because now different public authorities in those countries want to use the data for other reasons. So we have to really guard against this in the EU, this sort of mission creep. And my third and final point is that we shouldn't also forget the international implications of collecting personal data to fight COVID, because it also has implications for international data flows. Of course, measures to fight COVID also often require the data be shared across national borders, such as by establishing data sharing platforms for research data, enabling the worldwide tracking of mobile phone users, et cetera. The pandemic knows no borders. It doesn't respect our legal borders, our political borders, and therefore, if we're going to collect data, we need to enable this to cross borders as well. The GDPR also doesn't prohibit this. It does contain legal bases that allow the international sharing of personal data to fight pandemics. But again, this is under strict conditions. So, for example, data can be shared across EU borders under the GDPR for important reasons of public interest or to protect the vital interests of the data subject. But these are not situations to be used broadly. They're to be strictly construed and to be limited strictly to their purposes. So I think this will require the EU to monitor closely whether data transfers to third countries receive adequate protection, and to build in COVID-related considerations in developing its law and policy dealing with international data flows, for example, with regard to adequacy decisions for third countries. At the same time, we shouldn't only be worried about third countries. We have to ensure that the member states themselves respect data protection in the collection of data to fight COVID. This is, I think, a crucial aspect of the rule of law, and it's easy to become very worried about third countries and forget that this has to be ensured also here within the EU. I think the EU and the member states can make a valuable contribution in this regard by demonstrating that they're capable of digital solidarity, for example, by moving towards EU-wide solutions to combat the virus, such as an EU-wide COVID app. And this is, I know exactly what the EDPS has called for, and I would strongly support that. So quickly, a minute or so as conclusions. As governments, regulators, and individuals grapple with the pandemic, it's important that data protection and privacy be built into the solutions that they develop. So this shouldn't just be an afterthought. It's always a bad idea to make data protection an afterthought, even in normal situations. And in this sort of emergency situation, it would be catastrophic if data protection was not built in from the beginning, and it would also mean that individuals wouldn't even accept the solutions that are being proposed. And this includes mechanisms to protect data shared across borders. So I think data protection authorities should make issues of global data sharing a key component of guidance they issue, and together with data controllers should explore the use of novel mechanisms to provide protection for data processing. This is necessary both to ensure that personal data are processed in accordance with the law, and also to protect the values of legality that form the basis of our democratic societies, because that's what we're really talking about here. So I think I'm within my time limit, and there's certainly a lot more that could be said, and I'm sure will be said in this webinar, but I'll leave it at that, and I thank you for your attention.
Thank you so much, Professor Kuhner. Thank you for sharing your thoughts, in particular on the underlying risk of surveillance. I'm sure that this will be touched upon by our next speaker, Maria Paz, at the risk of underlining surveillance from the public and the private sector. Thank you for touching upon the function creep, which is, of course, the very center of the attention of the data protection community. Of course, the question remains on whether to draw the line. And if you allow me a personal remark here, a personal reflection, I think has been important in the context of this pandemic vis-a-vis the mobilization, let's say, the reaction from the wider public. I think we testified actually an important level of awareness, at least around the general public on the underlying risks for our rights to privacy and data protection. But I'm sure that the discussion will touch upon this also later on and during the Q&A, hopefully. So I'm really delighted to introduce you our next speaker, Maria Paz Canales. Maria Paz is Executive Director at the NGO Directores Digitales, a non-profit organization which is active in Latin America and which is active in the defense and promotion of human rights in the digital ecosystem. Maria Paz will bring the perspective of non-European voice of civil society to this debate, and we are very grateful for that. Maria Paz, over to you. Thank you.
Thank you, Anna. It's my real pleasure to be here today and an honor to be invited from outside the European Union to provide some perspective about the issues regarding data protection impacts and human rights impact of the pandemic. I think that this is a very, very, very complex and deep topic that it's difficult to cover just in a few minutes, but we already have heard from Professor Kuhner some of the key components of this discussion, mainly all the reminder of the validity and necessity of keep the principles of data protection in mind and remind that neither the crisis or any exceptional situation that we can live make a real exception in the necessity to stick to those principles. There are rules in general that are contemplated for balancing the rights that could be conflicting in difficult situations like this, and those rules doesn't mean to forget the validity of those principles. It means that they need to be balanced and combined in a different proportion and with a different sensitivity, but never forget them. And why is that? Precisely because data protection today is not about just the protection of the right to control information about ourselves. It's the doors that enable the exercise of other human rights in general. So when we have a lack of strong data protection in different jurisdictions, what we have is that many social interactions that are mediated by massive collection of data, either by public or private sector, can result in negative impacts for the exercise of a different number of human rights that go beyond even the political and civic rights that are more on top of mind when we think about privacy and the impact of privacy. As Professor Kuhner already mentioned, the use of data today in the context of COVID crisis, but also in other contexts, can imply discrimination in access to labor opportunities, health, the access to welfare or social benefits from the state. And the menace can come from the private agents and also from the state. And this can be impact that we can feel not only at the moment of the data collection, which is something that is constantly reminded in the context of COVID, in which the actors that try to collect in a more intensive way data for this particular crisis, they say that we will be using just for now. But the risks, precisely what Professor Kuhner was explaining about how this can last to this function creep issue, and not only can be used now, but also in the future. So in the context of COVID-19, precisely the issue is that we see a combination of factors that imply that there are a lot of interest in the power and the ability of the data for being leveraged for improving the strategies for fighting the pandemic. And that it's very real, and it's something that we should attend in terms of provide more elements and tools for being more efficient for the fighting of the pandemic. Although the issue on this is that precisely in this context, when we look into alternatives for where to pick that data and what kind of technology to use for that data collection, what we are seeing is that in many cases what is being repurposed is technology surveillance that already have been in place for a while for different purposes, for example, national security purposes or in public safety narratives, the fights against organized crime or terrorism. Many tools that were designed not having precisely in mind the protection of the health of people, and many times technology that have been deployed without having this data protection consideration by design that Professor Kuhner was speaking about in his intervention. So we have issues around the world that are linked to the collection, massive collection, or attempt to use with the fighting pandemic purpose, the communication data, the geolocation data that is collected by mobile operators, the GPS data that is also collected by them, and also other data that comes from body surveillance that happen through facial recognition or other biometric techniques or even drones. Those all are examples of technologies that haven't been developed with the purpose of a crisis like this. And each one of them has particularities in terms of their efficiency or the aptitude that they have for really make a meaningful contribution in the fighting of the pandemic, but they also have a lot of issues in terms of the limitation in what can be done with them without infringing and violating not only the right to privacy, but other human rights. So here's where we should remind one of the basic principles that Professor Kuhner mentioned regarding that we need to understand that data processing always should be based in the purpose of the original collection of the data. It's not as easy to repurpose the use of the data that was before collected with other purposes and with other safeguards that were designed looking into those purposes. So many of these technologies are also problematic because in the past, in other places outside the European Union, probably more often, have been used against social movements, human rights defenders, and political dissidents. So how we can look into what is new regarding the use of these technologies? The fundamental difference that the narrative have shifted, because we heard all the time that we should kind of suspend or give up a little bit at less in our rights in terms of being more efficient in the fighting of the pandemic. And as Professor Kuhner was pointed out, this is a false dichotomy. There are many ways in which data can be used in a balanced way for improving the policy making regarding the pandemic, but it doesn't put the risk of violation of human rights through the implementation of these technical solutions that are fitted with this data. But for that, as Professor Kuhner was mentioning, it's essential to have a legal framework that precisely provide the basic principles and the exception that we could use in this kind of problematic cases to balance the rates at place. And this is something that sadly is not the reality for the majority of countries around the world, and particularly in my region in Latin America, in which even if we, since the very beginning of the development of our data protection framework, we have been following closely the guidelines and orientations that come from Europe. We are not in the majority of the countries at the stage of what GDPR provides for Europe, and we don't have clear frameworks with strong data protection authorities that can deal in general with the protection of data, but in particularly in these cases that can be part of the solution of the balancing of the rights in place. So this is a very, very complex issue, and it has a fundamental impact in the way in which today in other jurisdictions outside Europe, and particularly in Latin America, the issue of the data collection for the purpose of fighting the pandemic is being conducted, because basically this has become an administrative matter in which governments are making decisions and implementing technologies without enough participation and counterbalance of other authorities that could be trying to protect and oversight the implementation of this solution in order to verify that they are protective of the data of the privacy of the people. So I would like to provide some specific example of this just for closing my presentation, because I think that we can discuss more about how these issues can be balanced later when we are in the Q&A section of this seminar. But just for providing you more concrete example of how this last point that I was raising is reflected in the reality in my region, I would like to provide you 3 examples. One example that I want to bring to you, it's from a country from Latin America that doesn't have a data protection law at all. So this is one of the few that doesn't have any legal framework for protecting data is Ecuador. They have the recognition in the constitution of the right to privacy, but they haven't been able to pass any law. They have currently one that is being discussed in the parliament, but they confronted the crisis of this pandemic without data protection. And one of the things that is very common in Latin America in this moment of crisis is the passing of emergency laws, decrees that granted exceptional powers to the executive branch of the government. So in the context of Ecuador, for example, this emergency state was declared, and in the decree that declared the state of emergency, there was a provision that allows the government to have full access to satellite and mobile phone platform in order to use that data to localize and monitor people that was put in sanitary quarantine. So this that probably in a different setting in which data protection framework and with an oversight authority could be something that you could consider that in certain conditions could be compatible with data protection. In this particular case, it was not, because there was no guarantee that the data that will be collected in according to this provision will particularly only be used for these purposes and not for other as the ones that were mentioned by the Professor Puner. So, for example, law enforcement or the prosecution of political opposition, many different issues that had happened in the past in this particular country. This country also has the last year a huge leak of the database of the citizens that impact very heavily in the exercise of privacy of the citizen, and there's no any provision in this decree that look into the security of this data. So all this situation of using this data in this COVID context will be impacted by the very fact that there is no legal framework that protect or an oversight authority that could verify the good use of the data. The other 2 cases that I want to bring quickly are very similar in between the 2, but represent also 2 other problems. Brazil and the case of Colombia. In both cases, what was provided as part of the emergency policy measures that were taken by the countries, it was also the access to the data from the subscriber of mobile phones and telephones provided. And the thing is that in the first case, in the case of Brazil, we have last year a data protection law that it was passed and is supposed to enter in vigor this year. But because of the context of the COVID crisis, the government suspended the implementation of the law. And even in the passing of the law, they didn't consider the establishing of an independent authority that could oversight the data protection provision. So they had immediately a constitutional issue regarding the access of this data in this COVID context, because there were no guarantees of proportionality in the use or oversight or any kind of guarantee about the security in the access of this data that will safeguard the correct use for the pandemic. So this is a lost opportunity for this country, because finally the Supreme Court overturn the provision from the executive for accessing to this data, and we finally ended in the worst case scenario, which is that because there's not a provision for the correct use of this data or the oversight, the data will not be accessed at all and used for the fighting in this pandemic context. And the last for closing, just I'm aware that I'm a little bit over, it's Colombia, which is very similar to Brazilian case, also a executive decree that provides access to the data of the operator. And in this case, the problem that we have in the legislation is even if they have a good data protection law that is close to the standards in the European Union, when they established the authority for oversight the use of the data protection provision in general, they didn't provide the jurisdiction for oversee the use of the government from the data. They separate the jurisdiction and they only granted to the data protection authority the power to oversight the private sector. So for example, in this case, it's very problematic that all these measures of access to the data from telephone companies are not covered by the possibility of being oversight by the data protection authority, and immediately that provides a lot of uncertainty, and there have been a lot of resistance and lack of legitimacy in many of the policies of the government implementing this use of the data for providing, for example, welfare benefits in this context of crisis, because people doesn't trust that the data will be used correctly, and in that sense that make more difficult to make more effective the issue of the using of this data and the collaboration of the citizenship in applications that have been developed by the government that in part use this data that comes from the operators, but also try to communicate with the public and trying to get more data for them for complement and provide a better help to the people in the context of crisis. So I will leave it with those examples. I think that we can have a rich discussion about how we can leverage the international framework of human rights in this particular context, in these cases in which there are no clear legal rules implemented at the national level. Thank you very much.
Thank you very much, Maria Paz, for your presentation. I'm sure we will have time during the Q&A to address further some of the points you raised, and I take the opportunity to warmly invite and encourage the trainees who attended this session to ask questions in the public chat function. Now we'll turn to our third speaker, who is Gary Davis. Gary is Global Director of Privacy and Law Enforcement Request at Apple. He will bring the corporate, the business point of view to this debate. Over to you, Gary, and thank you.
Thank you, Anna. And I think I've been given a number of topics to cover today during my intervention, so I will do my best to cover those off in the time allotted to me, or if we're all very lucky, even less than the time allotted to me. First of all, thank you for inviting me here today to participate on the panel. I am honored actually to have the opportunity to talk to you all on data protection in the age of COVID-19. I should say, however, that the event is tinged with some sadness from me, as the last time I share a public platform with European Data Protection Supervisor was on the 1st of February 2019 at the CPDP conference in Brussels, which turned out to be the last time I had the honor to be in the company of Giovanni Bucciarelli, whom I considered to be a close personal friend of mine. I, in fact, was extremely fortunate that he was always generous of his time to me throughout my career. From the first time that I met him in 2006, when I was the Deputy Data Protection Commissioner in Ireland in my former life before Apple. And I'm pleased to see already that Wojciech is embodying those same principles in terms of actually sharing his experience and expertise with the youth in our field, which maybe back in 2006 I qualified when Giovanni was helping me and guide me in that direction. Now, for the good news for you all whose career is tied to respect for individual privacy and data protection, is that actually COVID-19 and the response to it has reaffirmed that the fundamental principles of data protection, in fact, remain alive and well. If anything, in fact, we have seen over the last several months that now, more than ever before, they are important to us all. So I would, in fact, echo what I heard Chris say earlier, that data protection is going to continue to be a growing career for those of you who are bitten by the bug and an area that you wish to pursue over the coming years. Of course, it is easy for me to say that we have seen over the last several months the principles of data protection be more important than ever been before. But I thought maybe what I would do is take you through a little bit the last couple of months of our experience in dealing with COVID-19 as Apple and also working together with Google. And where it really kicked off for me actually was on Saturday afternoon, the 28th of March. Gone, which we were already, I guess, well into lockdown at that stage in Ireland. And I joined colleagues from Apple, from Cupertino and Ireland on a call with the Irish Public Health Authority in relation to the support which they were seeking from us in relation to Bluetooth, and particularly where they saw Bluetooth as an opportunity to establish close contact between persons subsequently diagnosed with COVID-19. And obviously, there had already been some apps which had been made available, such as the Singapore Trace Together app. And somewhat countries were looking to see if that was a framework where we could help them develop. Over the coming days and weeks, those contacts intensified, days, weeks, evenings, weekends, in fact, and they culminated in Apple and Google announcing an unprecedented initiative on contact tracing on what was Good Friday, the 10th of April passed. And on that day, we spoke to many people in relation to our announcement, including Wojciech, who was back home in Poland. And he mentioned it earlier himself. He took a screenshot of it. I think I knew that. He was joined by Anna Bukta and Thomas Zerdick and many others from your office who actually put aside their public holidays, as many have throughout this emergency, and joined in a conversation with Google and ourselves in terms of trying to guide us at that moment as to what was the best way to build this. And that is a dialogue that has continued throughout the process. And I think, as Wojciech also said earlier, if someone had told me at the start of the year that one of my closest colleagues in the workplace was going to turn out to be my counterpart in Google, William Malcolm, I would have obviously laughed at them and told them, no way is that going to be possible that I will be working so closely with William. But that has indeed been the case. There has not been a day that has gone by over the last number of months where I have not been talking to, emailing, or messaging with William for this common good that we are seeking to achieve here. And so in the weeks leading up to our announcement on the 10th of April, Apple and Google received an unprecedented level of contact from public health authorities around the world seeking our help in terms of creating interoperability between Android and iOS devices so that we could have a larger population coverage for the efforts which public health authorities were very anxious to try and put together. So therefore, our response to work together, Google and Apple, was a response to these contacts which we were receiving and what was clearly unprecedented demand to respond to this unique situation that we all found ourselves in. However, what was clear to both Apple and Google is that some of the contact tracing initiatives which we were hearing about did pose a risk to privacy. And in fact, if they had been adopted and become the standard, they would not have served anybody's interest in this space because they lacked one thing. They lacked an ability to maintain user trust. And without user trust, the major thing that public health authorities were seeking, broad adoption, would have been impacted. And that's a place where achieving broad adoption and tying with it user trust is where the fundamental principles of privacy come in. Now, we, of course, here in Europe, and Marie Praz has outlined it for outside of Europe, we're fortunate in that we have a strong legislative basis that protects privacy. But even here, I think we need to be clear that a legislative basis on its own cannot achieve or maintain trust in relation to the use of citizen or user data. It needs more, in fact, in terms of maintaining that trust. So in fact, one of the areas is that we, as Google and Apple, we were very clear that we wished to be absolutely open in terms of what it is we were developing to support public health authorities. And that is why over the weeks between our announcement on the 10th of April and when we launched the Exposure Notifications API on iOS and Android on the 20th of May, we held numerous sessions with public health authorities, governments, some of our most senior people in Apple, and Google with those people to hear what they needed so that we could build towards it. Privacy regulators, obviously, many contacts with them throughout the world, not just here in Europe, all over. Privacy advocates clearly have had a strong role in terms of what we have built towards, and of course, governments themselves. And so transparency in terms of what we're doing and what we have been doing has been absolutely key. And it's a minimum requirement, but it's not sufficient on its own when public health authorities want and in fact need that broad rate of adoption where public trust is maintained. So therefore, the second principle from those fundamental privacy principles that we have all been very focused on is that of data minimization. So extreme transparency clearly in terms of how data is being used and what it will be used for. But then, of course, having transparency will not encourage people with reservations to adopt. They are still going to have those reservations. So one of the ways in which we all try to deal with that is we actually ensure that we have absolute data minimization built in. And so therefore, together with other initiatives that were emerging around the same time, such as the DPT3 initiative, we focused on a decentralized system, which maintained control fully in the hands of users. And, you know, I think as we've already said, we made a decision early on that location data was not necessary or desirable for the efficient operation of a contact tracing technology system. Now, I do want to be a little bit clear because I find there is sometimes a lack of clarity as to what it is that Google and Apple have in fact developed. We did not develop an app. We made updates to our operating systems to allow iOS and Android devices to exchange what are random Bluetooth identifiers that are rotating every 10 to 20 minutes, where individuals are within a distance to each other or for an amount of time that has been chosen by their public health authority, not by Apple or Google. It is in consultation with those public health authorities, and then they tune their app as to what is the appropriate amount of time or what is the appropriate distance in which an individual should be in close contact. The Bluetooth identifiers, and this is crucial, do not reveal user or device identity or location and are stored locally on the user's device when they have been together for that amount of time decided by their public health authority. Equally, a user must actually specifically enable the exposure notifications API when setting up the public health authority's app, which must be downloaded. And they can disable the service and delete those Bluetooth identifiers at any time on their device. And that is something that we've worked very hard to build into the system. The keys, in terms of the match that was made, again stored only on the user's device, nowhere else, unless the user is reporting a positive diagnosis to the public health authority. Only when they report that positive diagnosis to the public health authority do those diagnosis keys leave their device and go up, and where a match then is performed on the devices of those persons that they may have been in close contact with. Equally, because the period of infection, thankfully, is known and known to be roughly 14 days or more likely 10 days, the keys where a match is made by two devices roll off your device every 14 days. So there's a rolling window of 14 days kept on your device, but no longer than that because, again, the principles of data minimization would not require it. And users who test positive and share that diagnosis with their public health authority, they're not identified to other users, Google or Apple. that is crucial, Google or Apple receive no data from the operation of the exposure notification API. We were very clear from the beginning that that was a fundamental point that needed to be made clear, that we were just developing some technology to assist public health authorities because of the needs and demands that were being articulated to us. Now, I am glad to say that the journey from that call on the 28th of March that I mentioned earlier with the Irish Public Health Authority actually reached fruition last night for me when the app was launched here in Ireland, and I downloaded it enthusiastically and enabled specifically the exposure notification system on my device, which, you know, I'm proud to say that together with many colleagues, I played a very small part in ensuring that we built a privacy-preserving contact tracing framework, exposure notifications, that has actually helped or will help in combating COVID-19 as more users here in Ireland. And I think by early this morning, after a few short hours, 40,000 individuals in Ireland had already downloaded it in advance of a big push by the government. So I think that is gratifying to see that level of take-up of something that we've all worked very hard on. Now, I know there are questions in relation to the efficacy of the system. So it's great to know having something like exposure notifications, but, you know, does it actually work? And obviously, that's a key point that we all should be assessing as we go on. And again, as Wojciech mentioned earlier, I spoke at a webinar yesterday together with colleagues from Apple and Google, organized by the Global Privacy Assembly, where we talked through in more technical detail the operation of the exposure notifications API. And I was actually pleased to hear in that session the Office of the Swiss Federal Privacy Commissioner, where the app's actually been available in Switzerland since the 18th of June, indicate what I heard was 30 cases already identified as a result of the operation of the app in Switzerland. And Switzerland is one of those countries that we worked extremely closely with for many months, in fact, in terms of trying to ensure that what we put in place was actually responsive to the public health needs as well as the privacy needs from the operation of it. Now, obviously, we're continuing those conversations. We made the exposure notification API available on the 20th of May, as I mentioned. We've continued the intensive conversations with public health authorities ever since then. And there will be updates. There's updates always to software to take account of refinements, to take account of areas where it could be improved. Is there a difference between exposures that are inside and outside? A whole range of areas, actually, that we are trying to be extremely responsive to. And the most senior people in Google and Apple are remaining actually very fully involved because we are committed to seeing this thing through in terms of actually helping public authorities achieve their objective. Now, I was also asked to address whether COVID-19 has changed the way technology companies work with governments. And I think I heard in an intervention that Wojciech made at the start, maybe this was his thought. Now, I can, of course, only speak about Apple in that respect. And we have always maintained close contacts with governments in the countries in which we operate. This is a fact of doing business, something that we focus on and pride ourselves on. Now, sometimes, of course, they ask us to do things such as with exposure notifications that align with Apple's values, and therefore it's easy. Sometimes they ask us to do things which do not align with Apple's values, such as where we're asked to undermine encryption in certain places or countries. And obviously, when we're asked to do those things, we will have a different conversation. But in this instance, this was clearly something where we could really apply Apple's basic privacy values and principles and produce an outcome that was going to be hopefully great for everybody and show, in fact, for the benefit of all of us, that privacy principles can, in fact, be maintained even in an emergency situation. As I indicated earlier, in fact, show their real worth at a time like this. And certainly, as I heard Maria Paz indicate earlier in her intervention, at the start of the crisis, we saw some governments publicly indicate that they felt that the pandemic was such a threat that fundamental privacy principles would need to be put to one side. There was a number of countries that had that view. Now, I'm actually glad to say that thankfully, as we have all worked on this together, those countries have been able to put that initial view to one side and understand, in fact, that those fundamental privacy principles support them. And I think that's something which we should all be very committed to as privacy professionals and public officials working in this space, to actually trying to ensure that we respect where privacy can actually help us all achieve our objectives. Now, I was also asked to address whether our exposure notification framework, and I'm just finished actually, Anna, where our exposure notifications framework would lead to less manual contact tracing. That's going to be a matter for the individual public health authorities, but from talking to them, I have heard them say that it is just going to be a supplement to it, not something that will now replace the people actually making phone calls, because they're very anxious to continue to be that. And then second to final, the question of function creep. Well, we have built an emergency brake when we developed the exposure notification API. And this was something we were very public about, which is that we have, Google and Apple, an ability to remove the API on a regional basis as the pandemic eases. And that is something that Apple and Google were very strong about putting in place because of this unknown function creep that none of us could imagine or predict at the start. And then finally, there was a question in relation to temperature checks for accessing buildings. And I will say yes, in those countries where public health advice has advised that it is the right step to put temperature checks in place, Apple has sought to put those in place in response to that public health advice. But being Apple, and as you would expect, privacy is our bottom line on these things. And we even went to the level of ensuring that where that temperature check is collected, no data is collected. And we went through every CCTV camera to ensure that the collection of the individual being temperature checked could be picked up, because we absolutely did not want any data of that nature in our systems because it was not needed. And with that, I will pass you back to Anna for any questions.
Thank you very much, Gary, for your presentation. As said, we have now time for questions. So I'd like first to address you the first round of those, and then if we have time, I'll go for a second round. So the first question is addressed to Professor Kuhner, and it's about function creep. Could you shed, read the question, could you shed some light on possible measures which may be suitable to prevent function creep, for instance, in the context of contact tracing apps?
Yeah, sure. There are three things that come to mind, which are broad categories. One is just ensuring that the principles of data protection are respected, because the function creep is inherently incompatible, I think, with data protection law. Data protection law has all sorts of protections built into it against function creep. So, for example, purpose limitation principle, as I said, to ensure that data are only used for the purpose for which they're collected. That's kind of inherently would go against function creep. So we need to be sure that the principles of the law are respected. And secondly, there are certain technical measures, I think, that can be used to fight function creep. And I'm thinking of things like what are called data protection impact assessments, data protection by design, data security. These are all principles contained in the GDPR. And if they're respected, then the risk at least is greatly reduced, I think. And third, this is really an area where the data protection authorities have the absolute crucial role to play to police the collection of this data. And I know that they're doing this. I don't envy them now. I don't think they have the easiest job, and in addition to everything else they had to do. But this is really a function. I don't think there's any other party that could fulfill this role in terms of being independent, really keeping the public interest at heart, and being experts, obviously, in data protection. They have a very special role, and I think that's probably one of the main things they need to focus on, is to be sure that when personal data are collected to fight the pandemic, that it's really not, there isn't some sort of access to the data through the back door. It's not used for some other sorts of purposes.
Thank you very much, Professor Kuhner. Maria Paz, I have a question for you about the Brazilian case, actually. So, in your opinion, what kind of guarantees for the Brazilian case should have been put in place to ensure the correct use of data?
Yeah, as I mentioned it when I was explaining the case, one of the fundamental issues is that they didn't have a data protection legal framework in place. So if they will have the data protection legal framework in place, they will have the clear principles that Professor Kuhner has explained before in his intervention, and those were implemented in the text of the law that was passed last year, but the law was not enforced. And the other thing is that they should have an oversight authority, independent and technical, that could oversight the fulfillment of all those principles and obligations. So at the end, without having that implied that any kind of regime that granted the access to the data that was being requested in this administrative instrument will kind of make those rules in a law dictated in an emergency context. So at least implement some measures regarding the limitation in the use of the information, more transparency about how that will be oversight by someone else from different power inside the government. That kind of measure that will be like a small substitute of a full legal framework for data processing, but those will be the minimum that at least should be implemented in order to prevent precisely what Professor Kuhner was explaining, the function creep, so that the data was allegedly used for COVID fighting, but at the end it would be used in any kind of purpose for the government. And also in this, I have to be even more precise that this is particularly careful in a political context that currently it's highly problematic in that country, in which there are not much public trust in the different political forces and the government in place. So all that also make much more difficult that the implementation of a kind of exceptional legal regime for processing this data will not be supported by the citizenship, because they lack of trust fundamentally in the authorities that are behind this kind of process.
Thank you. Thank you very much, Maria Paz. I have now a question for Gary. So to what extent is the control at big tech, Apple in particular, has on issues of national sovereignty, here on privacy and health, democratic?
So I think I can only speak to the situation that we found ourselves in, which is that we started receiving the types of contacts that I spoke of from public health authorities throughout Europe, who wanted our assistance with our technology. The technology is one that we had deployed. We built in privacy protections, actually, in terms of how Bluetooth could be accessed when an app was being used. Our devices were not usually speaking to Android devices in terms of Bluetooth. And so the update that we made was to support those governments who wish to use Bluetooth in that way, but within a framework that protected privacy. No government was required, obviously, to use the framework that we put in place. It was one which we felt was responsive to the specific requests that we were receiving. And obviously, there are governments which made the decision to go a different system. And that is perfectly fine, obviously, because our role here was to support them in reaching their public health goals. And I believe that is what we have done.
Thank you, Gary. Thank you for this answer. Wojciech, over to you for a question. In your opinion, should the adequacy decision for Israel be renegotiated, in light of the extent of surveillance going on there?
Of course, sorry, I will put my headphones, the sound will be better. Of course, it's hard to use this. It's hard to use this example as the only one that is taken into consideration. We have to remember that the European Union is going to check all the agreements that exist at the moment and the decisions on adequacy that have been done under the previous rules, if they still can be kept under GDPR. I'm sure that the experiences of Israel will be taken into consideration where this decision will be discussed in the European Union. However, we have to remember that these are not only bad experiences that we have in Israel. There is also a very important thing which happened there, at which we have to be aware of. Everything is about the Hamagen, so-called shield app that has been created there. And the app was revealing where the user was over previous 14 days, and was informing about all the situations where the person was in the proximity to the person infected. After the user installed the app, it was keep tracking his movements, and compared it with the information in the health ministry. And if the person was diagnosed as infected, the app was finding the match, and that the user was at the same area at this time, and the smartphone owner to the health ministry website for the information on what to do next and how to register for the self-quarantine. What happened with this app was that Israel's Supreme Court has banned the intelligence agency Shin Bet from tracing the phone's locations in this way until the new law have been passed. So there was at least a very good example of the of the judicial review over what's going on in the country. So there were the bad experiences and the good experiences coming out of that. We have the same situation in some countries of the European Union where the quarantine apps were used. We have to remember that the contact tracing apps, that's the second generation of the apps which were introduced in many countries of the European Union. And the solutions which were prepared in the other countries have also been questioned by the authorities, by the judicial authorities. So we had the same situation in Israel. We had in the countries like Slovakia, for example, where also the actions of the government have been questioned by the courts. When Europe is assessing if the country is giving the adequate protection, the assessment is taking into consideration all the aspects, including how the supervision and the judicial review is taken into consideration. So it will be definitely the part of the review that the EU will do.
Thank you, Wojciech. I'd like to see if we can go for a very quick second round of question, and I will be asking to our speakers to really limit their response to 30-second max. I know this is mission impossible, also because the questions are quite important. So, Professor Kuhner, how is the COVID-19 crisis going to impact the data flows between EU and US?
Well, quick answer is I suspect this may be, of course, it may have some impact because I suppose there is a lot of research data going to the US, but I suspect this may be an area where the data flows to the US may not be particularly affected more than other countries because this is a global pandemic and there's medical research being done all over the world. There are contact tracing that needs to be done with regard to travel all over the world. So I think we have enough problems with the EU-US data flows, and I think this may be impacted in some way, but I don't see it as particularly affected. And there may be other countries where data flows from the EU are even more important in this regard.
Thank you so much. Maria Paz and Gary, I have a question for you both now. To what extent, and then one for Gary specifically, to what extent should the public good as defined by governments trump the fundamental right to privacy? And then I'll address one to Gary as a which is part of the same question. Maria Paz, you have the floor first, and then we hand over to Gary.
Sure. I think that the issue of the public good as something separate of privacy protection, it's wrong. I mean, it's a false dichotomy, as we were talking in the first block of this conversation. I think that the privacy is part of the fundamental good, and the thing is that a implementation like the one developed by Apple and Google, and the work in the DP3 protocol and other protocols, privacy respecting protocols that have been developed, prove that it's possible to do this contact tracing without harming privacy. It can be carefully designed for being privacy protected. So there is not a necessity of choosing between privacy, because those are part of the same thing. And just a short word regarding, we should be careful in terms of analyzing the different technologies that are being discussed in this context of the pandemic, because contact tracing, it's one small part of the set of solutions that have been deployed. So as what was mentioned before, there was other a group of applications that were developed before or even in parallel to contact tracing application for oversight quarantine, that in many cases were much more problematic. So at the end, the question about public good, it's about how being very critical about the type of technology that is being implemented to address specific issues linked with the pandemic. It's not the same technology that can be implemented with informational purposes, with contact tracing purposes, with the purpose of providing an oversight of the mandatory quarantine, the other technologies that are being implemented to monitor voluntary measures by the citizen. So I think that the public good will be in a critical exercise of how each one of these different technologies that can be implemented in the most privacy-preserving way, not only to protect personal data, but also to protect the exercise of other human rights, as I mentioned in my first intervention. Thank you.
So I think I will give a non-Apple legal answer in terms of the public good. Obviously, that is something that we're all very comfortable with here in Europe, as it's actually explicitly recognized within the legal framework that we operate in, that governments have an ability to determine the public good by passing an explicit legal basis, providing for the processing of personal data. And throughout the pandemic, we've actually seen governments determine the public good in a whole range of situations, whether it's data necessary for accessing premises, data necessary for return to work scenarios. We have seen a whole range of those, and I believe the EDPB, in fact, in its guidance has actually highlighted the desirability of governments determining that public good by passing legislation. And obviously, that is something which, if they go beyond the framework of GDPR, we have the Court of Justice of the European Union, which is very well able to try to determine what that public good is in a European context.
Thank you, Gary. The final question that I was referring to is the following. There is a request for clarification on for which governments or countries did you develop this contact tracing service? And then we'll stop here.
Okay, sure. Well, we didn't develop it for anybody in particular. Actually, as I mentioned, we were responding to a large number of countries, many in Europe, actually. I mentioned Ireland, Switzerland, obviously, Germany, Italy, Spain, Netherlands, Latvia, Croatia. We have a large number of countries that approached us here in Europe to come up with a solution and help them. But the solution was designed to be helpful to all countries who wish to avail of it, and all public health authorities who wish to avail of it, because it's simply just an update to our operating systems. And then countries, if they wish, could develop an app, or they could actually still, and we see many countries doing that, develop an app that just does not use the exposure notification API. And we have approved many of those for our app stores because, you know, they have respected privacy in a particular way, just not using our exposure notification API.
Thank you, Gary. Against what I said, Wojciech, I have a final question for you. So indeed, there is a tension in society regarding the use of personal data. However, it does not only involve the relationship between citizens and government. What about the use of data in research?
This topic was probably the second biggest one that was discussed during the COVID crisis. And I would say nothing especially new have been said, because actually that was only the acceleration of the discussion which was going on even before. We have to remember that GDPR has some special rules and special parts helping in interpretation of the rules in GDPR, which are addressed to the research community. And the data protection in the research is definitely one of the main subjects that the European Data Protection Supervisor wants to deal with. We have issued the initial opinion on that at the end of 2019, and now we are going to follow up with the discussion about the subject with the scientists, starting with those who have the experience in the exchange of health data, which is at the moment the most important subject.
Thank you, Wojciech. Unfortunately, we ran out of time, so I must stop taking the questions now. But we are hopeful that you found this Q&A session as much helpful as possible. I would like now to ask Isabel Verheyen, the head of the EDPB Secretariat, to give her concluding remarks. Isabel, we are thankful of having you with us today, and the floor is yours.
Thank you very much, Anna. So I would like to thank first our fantastic speakers today, because I'm sure that everybody really in this webinar and learned a lot. I think we will need also to thank our trainees at the EDPB and the EDPS. First also, they selected a very interesting area. It has been underlined by different contributors today. But also, it's really a pleasure to work with them on the dailies, and we really consider them as a full staff member. And they always surprise us with fresh ideas, so it's a pleasure to have them. So I've taken a different point, I think, coming out of this session. First, the idea of this exceptional circumstances, that the pandemic constitutes one of the largest public health crises in living memory. Government, businesses, and societies have never been challenged in such a way, and also globally in the scope like that. Wojciech made reference to the closing of the border that was the European stolen for him. The cooperation between big tech giants in this for this reason, so that was also a great development. As the virus spread, the working from home became the norm, and school and university were closed. Distance learning became the norm when it was possible. Most of our social life, in fact, continued only on video meeting platforms. So it was as if overnight the digital revolution really accelerated suddenly. Our online life became daily life with our personal data at the fore. And that leads to the second big point element that I would like to underline is the increase of risk that has been made due to this crisis. The risk for public and private actors, they are suffered maybe more cyber attacks also, but also the risk to have the data processed increased and the risk of reuse of information. The good news is that the awareness of citizens and companies on the importance of protection of data also increased. Professor Kühnel made reference to the risk of reuse of data that can become institutionalized. And now I will then turn to the role of our institution as EDPB and EDPS, and all the national European authorities that worked in that field. We stepped up to protect fundamental rights of European citizens. Over the last months, while in lockdown, European Data Protection Board and the EDPS worked tirelessly for the citizens in Europe. In the context of COVID-19, we published many documents that closely follow the development of all the legal challenges that has been raised today. We started already in a statement at the EDPB on 16th of March and 19th of March to try to already bring the first main key elements. Because we knew from the very beginning of the crisis that government and private actors will look towards a data-driven solution. And so it was essential to convey important messages. And it has been also raised, those messages today, for instance, by Professor Kühner. GDPR does not prohibit the processing of personal data, but subject to conditions. As the EDPB underlined, the data protection rules and GDPR do not hinder measures taken in the fight against coronavirus pandemic. And this was a very important message to avoid that this situation would have been used as an opportunity to put in danger our legal framework. GDPR is flexible enough and is able to achieve both an efficient response in limiting the pandemic and protecting fundamental rights and freedoms. So there's no need to choose between an efficient response to the crisis and the protection of our rights. We can achieve both. Moreover, data protection is indispensable to build trust. I will make reference to the intervention of Gary Davis on this, because it creates a condition for social acceptability of any solutions. We need to be able to rely on solutions without any fear. And any measure taken in these extraordinary circumstances must be necessary, limited in time, and respect the data minimization, and also be subject to a periodic review. After that, the EDPB, after those first statements, we accompanied also the European Commission to shape the legal conditions, but also the technical conditions for the use of contact tracing apps. We were consulted by the European Commission and we adopted some guidance. And in fact, we can see parallel with what Gary Davis exposed. We underline the principle that the apps need to be voluntary. Does not necessarily mean that it should be based on the consent as a legal basis for using it, but the user, the individual, should be free to use it or not without facing risks of bad consequences. This is also to build trust and adoption, as it was raised by Gary. Those apps should not rely on tracing movement and using data location, but should rely on proximity information using Bluetooth technologies. The apps should be auditable and the source code should be publicly available for the widest possible scrutiny by the scientific community. Maria Paz made reference to this counterbalance power, which is really needed in this area. The more people are looking for a solution and try to take part of the discussion, the better it is. We need to have also data minimization, data protection by design, to avoid to have direct identifiable information, but to use rather random pseudonyms. And we need to erase information at the end of the crisis and not reuse. And now I will turn to this idea of digital solidarity that has been raised also by Professor Kühner. The pandemic is a global problem and it requires a coordinated response. Our work has proven that data protection rules do not stand in the way of cross-border solutions to the crisis, but we aim to accompany the development of compliant solutions to enable the protection the public deserves. We have a special role as defender of data protection rights, and it has been confirmed also by this 2-year review of the GDPR. And so this EU legal framework we made reference to, we are fortunate to have this system. It has been also raised by many of our contributors. We have GDPR, but also still the implementing national law of the e-privacy directive. They aim to protect us for indiscriminate state and corporate governments. As confirmed by this review of the GDPR, we must celebrate the fact that more citizens are becoming aware of their rights and taking control of their personal data. We must celebrate DPRS provides with a suitable tool to protect our personal data, even in such difficult time. But as it in raised also, and obviously we saw by the intervention of Gary and Maria Luisa, we should not, having only theoretical protection, having a legal framework is not sufficient. We need to be sure that they will be respected into practice. We need to fight all to ensure the implementation. It's not only a problem of third countries. We saw the examples of Latin America where there were no legislation, but sometimes there were legislation but not respected. But we also face this issue in Europe when we had some decree in Hungary limiting the rights to the crisis. And we also made a statement on this at the EDPB. So, but it's not only then third countries, but also in Europe. And what is really important is that we can realize today that all of the people that were around this table of the speakers, NGO, professor, private companies, and data protection authorities, we all took part of this role to accompany and to try to find solutions to implement, to ensure that the rules are not just theoretical, but they are applied into practice and they will be respected. And so we all achieve this common goal of the respect of data protection. So this is also why it is so interesting to work in this area. You can see the different perspective of the different people that took part of this panel today, and the fact that they can, with their angle, participate to this common goal. So I would like to thank you again for your participation, and I hope that you all enjoy the seminar, and I hope that you will be all soon to a future event to the EDPS and the EDPB. Have a lovely afternoon.
Thank you, Isabel. Thank you so much for this. Dear participants and speakers, we've come to the end of our webinar. Thank you to all participants. Special thanks to our speakers for joining us today. But above all, thanks to the EDPS and EDPB trainees who made this event possible. Thanks to Adam, Anastasia, Anna, Claudia, Isabel, Laura, Michaela, and Simeon. I wish you a very pleasant afternoon and goodbye. Thank you.
Thank you very much.
Bye.
Bye.
Thank you, everyone.